Good morning, sir.
Good morning.
We're hearing from Mr. Beezer today.
Yes.
Repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Please take us.
Thank you. Before we begin, sir, I should say we're due to have the usual fire alarm test at 10. I propose we simply sit through it.
Yes, of course.
Please could you state your full name?
Thomas Matthew Beezer.
Thank you for attending the inquiry today to give evidence. Mr. Beezer, you've made two statements to this inquiry, and thank you for your written evidence. The first has unique reference number WITN 095101000. That was read into the record on the 2nd of February 2024, but as you called to give evidence now, I'll ask you to affirm it. Could I ask you to turn to that witness statement in front of you, please?
Yes, I have it.
Thank you. It should be dated the 13th of June 2023. And if I could ask you, please, to turn to page 32 of that statement. See, it runs to 82 paragraphs.
Yes.
And is that your signature?
Yes, it is.
You made a second witness statement on the 8th of May 2024. Could I ask you to turn to that, please?
I have it.
Thank you. And page 41, please.
Yes.
Is that your signature?
It is.
Now, as part of your statement, you have exhibited several handwritten notes or attendance notes of various meetings you had. You also exhibited typed versions you typed recently, transcribing what those notes said
to assist the inquiry.
Yes, and we're grateful for that. I understand that since you reread your statement, you have a couple of four corrections to make to those.
Yes.
I'll deal with those shortly now. Please, can we bring the first one up? It's WBON 301751. And if you could go right to the bottom, please. I understand that the first correction is where it says distraction at the bottom line. That should read distinction.
It should.
The second document, please, is WBON 301747. And about 6 lines down, I think it says, but only insofar as clauses times 12 or x12, and that should say clauses XYZ.
Agreed.
Thank you. Could we then please turn to WBON 301752? And if we could turn to the second page, please. Midway down, there's an asterisk, and it says, contract in corp is a problem in this clause. I understand that clause should read class.
Agreed.
And finally, could we please turn to WBON 301888? Being catch up myself, sorry. I think here, if we turn the page, please. On the third line at the end, it says Mayview brackets QC. I understand that should read my view.
Agreed.
Thank you. That can be taken down now. Subject to those corrections to the exhibit, are the contents of your first and second statement true to the best of your knowledge and belief?
They are.
Thank you. That stands as your evidence in the inquiry. The first statement's already been published. The second statement will be published on the website shortly. Before I ask you questions about your evidence, I understand there's a statement you'd like to make.
Yes, thank you. I'd like to take this opportunity at the outset of my evidence to reiterate my apology in my second witness statement to each and every sub-postmaster and mistress. I'm sorry that the recusal application added to the complexity and challenges they faced in the GLO. Additionally, I'd like to apologise to Mr. Castleton personally. I submitted a witness statement in the inquiry in its phase 4 work, and I had anticipated I'd be called in that phase. I had wanted and planned to make an apology to Mr. Castleton. In phase 4, had I been called, I was not. Hence taking this opportunity to now express my deep regret about the circumstances he and his family were placed in. At the time of the case, in 2005 and 6, I was confident in the assertions made to me by Pol about the robustness of the Horizon system, and I believed I was acting properly in accordance with my instructions when dealing with that case. However, with the information that has come to light over the course of this inquiry, my confidence in such assertions has been eroded, so I'm taking this opportunity to now say that I'm truly sorry.
I'd like to start with some background questions, if I may. You qualified as a solicitor in 1996.
Correct, yes.
And you joined Bond Pierce in 2003.
Yes.
As the inquiry knows well, Bond Pierce subsequently became Bond Dickinson.
Yes.
And Bond Dickinson then became Womble Bond Dickinson.
Yes.
I'll use the terms interchangeably, treat them as effectively the
Fine.
same body. You were made a partner of Bond Pierce in 2005.
Yes.
You remain a partner of Womble Bond Dickinson today.
Yes.
Have you practiced in civil litigation throughout your career as a solicitor?
Yes.
Do you have any experience of practicing criminal law?
No.
I'm going to primarily focus in evidence today on two areas. Firstly, the case of Post Office in Lee Castleton, which you've just alluded to, and second, the recusal application in the GLO proceedings. Before we do that, I want to turn to Bond Pierce, Womble Bond Dickinson's relationship with Post Office. In 2005, when you say you became involved in the Castleton case, you described the Post Office then as a significant client.
Yes.
Why did you consider the Post Office to be a significant client at that stage?
Bond Pierce had acted for the Post Office, I believe, for many years in a number of streams of work, commercial work, employment work, some litigation work. And it was a household name and a significant client. It was a client we were proud to have.
You've named a few streams of work there. You didn't mention criminal proceedings. Is that because Bond Pierce didn't take on criminal work?
In the civil litigation team, we didn't take on criminal work. There may have been parts of the firm that did criminal work. We have regulatory teams, for example. So I can't say no criminal work in the firm at all. I did no criminal work for Post Office. And
prior to dealing with the case of Lee Castleton, in a summary form, what experience did you have of conducting litigation for Post Office itself?
I find that quite hard to answer at this distance. It's 18, 19 years ago. I suspect it will have been some of the more complex debt recovery, I suspect. But I'm dredging my memory.
Please, can we bring up your first witness statement, which is WITN 09510100, and page 5, paragraph 12, please. Thank you. You make a point about an engagement letter relating to the Castleton litigation, and you then say, I cannot now recall why this was done, not least because my firm had a global engagement in place with Post Office throughout this period, and so far as I'm aware, at all times in our relationship. Could you please describe to me what you mean by global engagement?
I understand that you could call it a framework agreement, you could call it an appointment agreement. I can't picture it. I may never have seen it. I may just know that each year or at the recommencement of successful tenders, a new framework agreement between Post Office and its panel law firms was put in place. So there's a fully termed framework agreement, I believe, although I can't picture it, may never have seen it, I just know it existed.
And would that, based on your knowledge of it, or whatever knowledge you have, would that global agreement then be supplemented by individual retainers on specific matters?
It may have been. It may have been.
The inquiry heard evidence from Chris Ojar, who was General Counsel between October 2013 and March 2014, with some overlap with Jay McLeod, as a General Counsel of Post Office Limited. In his evidence, he described during that period that Bond Dickinson was so embedded within Post Office that in many ways they acted as an extension of the in-house team. Would you accept that as a fair characterisation of how Bond Dickinson operated with Post Office at that time?
2013, 2014?
Yes.
I probably wasn't much to do with the Post Office relationship at that time. So I can't answer that with any precision. I suspect I was doing no Post Office work at all at that time. As a partner in the firm, I would say we always had a proper lawyer-client relationship. But from my personal experience, I can't answer. I wasn't doing Post Office work.
In respect of when you were doing Post Office work, would that description be fair for any period of time which you were involved with it?
I don't think so. I did Post Office work in those early years, and then later on, as we will see in the recusal, but in the intervening years, not at all.
So we say early years, we're talking to...
Early 2000s, yeah.
When do you think you stopped doing that work?
It's a guess, but if you want me to guess, I will. 2007, 8, 9, somewhere like that. Before, yeah, probably 2007, 8, I dropped out of that vein of work and that relationship.
As a partner in the litigation team during that period, would you have had any oversight at all of the Post Office relationship, even when you weren't specifically working on the case? Specifically working on cases for them?
No, not oversight of the relationship. But as a partner in the litigation team, I would have had a connection with the people in the litigation team, yes. And that they may have been doing Post Office work, so I would have known about stuff going on. But we had a proactive relationship partner for Post Office. That wasn't me.
Who was that?
That was a gentleman called Simon Richardson.
We may come back to that period of time in due course. I want to look at the early years first, and let's start with 2005, please. And some emails relating to the case of against Gillian Blakey and David Blakey. Can we please turn to Pol 20142517? Pause.
Attention, please. Attention, please. This is the test of the fire and voice alarm system.
Right, I think that's over. We have an email on the screen here. If you could just scroll up slightly, thank you. So this is from a solicitor at Bon Piers. That Dave, is it Panesh? Panesh, thank you. It's to Cheryl Woodward at Post Office and Mandy Talbot, and you are in copy, and it's referring to sending a letter before action off on the Ruby Square Post Office case. Why would you have been copied in as a partner on a correspondence such as this?
Dave was a solicitor in the team. In those early times, I had a footprint within the post office relationship. I think that's why Dave is copying me in.
If we look for an email further on in the timeline, it's Pol 20142 please. From Dave Panesh again to Cheryl Woodward, you're in copy, dated the 22nd of November, and this concerns civil proceedings, and it sets out that particulars of claim were enclosed with the email. At the penultimate paragraph, it says that the facts of the case were ascertained from the documents prepared by the investigators in the POID file, in particular the witness statements produced in anticipation of the criminal trial, Paul Whittaker's report, and his interview of David Blakey. So at this stage, you were aware of an overlap in some cases between civil proceedings being brought by the Post Office and criminal proceedings. Is that right?
No, probably not. My read of this, when I was sent this recently by the inquiry, is that we were doing the debt recovery afterwards, is what I think, but I don't know that.
Let me rephrase my question. So you were aware that in some cases where you were instructed to pursue debts on behalf of the Post Office had prosecuted the people you were pursuing?
I believe that must be right from this email, yeah.
And presumably you were aware that Post Office relied on Horizon data when pursuing those criminal prosecutions?
Yes, probably, but I say yes, probably in answer to that question, because I think the first time that was gone into intellectually as a topic was in the Castleton case. Everything in the Castleton case suggests to me me and the people in that case are on that journey for the first time. You know, the language is, we're not saying, oh, we did this in the last case. I think that's the first forensic investigation. So
are you saying that, just to clarify, are you saying that Castleton was the first time you, at least you, turned your mind to data produced by Horizon being used as an evidential basis to pursue claims for debt?
Yes, I think so. But given that Horizon underpinned their business, the debts being chased at this time, if that's what's happening, because I don't remember this at all, must have been generated from Horizon.
And it seems that from here, Bon Piers were, as part of its debt recovery work, were being sent bundles of documents relevant to those criminal prosecutions.
That seems to be some of the background material that we sent, but as I say, I have no memory of this whatsoever.
It's a broad question. If a solicitor at Bon Piers at this time, who was handling a debt recovery action, if they had or discovered evidence that called into question the reliability of the Horizon IT system, to what extent do you think they would have a responsibility to consider whether that document or information ought to be disclosed to sub-postmasters convicted of theft or false accounting in criminal proceedings that relied on data generated by the Horizon IT system?
As a civil practitioner, I'm not sure I'm really placed to answer that. Can we unpack that question a little bit? So if there was a document that demonstrated the...
Well, let me unpack it. There's a civil practitioner dealing with a claim for debt. And that claim for debt relies on data generated by the Horizon IT system. That civil practitioner is aware that his or her client also prosecutes sub-postmasters for theft or false accounting based on Horizon data.
Yes, if that was what had happened in the Blakey case, but I don't know that.
Yes, but setting out some hypotheticals. In those circumstances, if that civil practitioner discovered evidence or information that undermined or tended to undermine the reliability of the Horizon IT system, do you think there was any responsibility on the civil practitioner to consider whether that document ought to be disclosed to sub-postmasters who had been convicted of theft or false accounting?
The specific sub-postmasters or sub-postmasters generally as a class?
Well, let's start with generally as a class first.
Do I don't know how to answer that, to be honest with you. I'm not trying to avoid answering it. It would need the civil practitioner to have sufficient knowledge of criminal process to be able to navigate those waters. It would certainly have an impact on the civil case that was on the desk at the time. Of course it would, absolutely. Would it trigger a solicitor out there in lawland to take on a proactive disclosure duty? I don't know the answer to that.
Oh, let's maybe let's not go as far as to say they have a disclosure duty, but do you think there's any responsibility to raise or discuss it with the client? Say, you may need to consider your criminal prosecutions or the criminal convictions.
If they had a full enough picture of what was going on, and so if a case on a desk if someone actually knew that the data that had underpinned a civil case or a criminal case was wrong, I believe there would be a conversation with the client.
I want to move to look at the Lee Castleton case now. It's a case inquiry is looked at in some detail in phase 4. Just to refresh on the background, Mr. Castleton was a sub-postmaster of the Marine Drive post office from the 18th of July 2003.
I believe so.
Yes.
Yeah, I believe so. We're going way back into my memory.
And following an audit on the 23rd of March 2004, the post office suspended Mr. Castleton because of alleged discrepancies.
Yeah, I believe so.
The post office subsequently instructed Bond Pierce to pursue Mr. Castleton for the shortfall as a debt.
Yes.
And this was initially handled by a team called CMS within Bond Pierce.
Yes.
A claim was issued and served on Mr. Castleton, and he served a defence and counterclaim on the 15th of August 2005.
Yes.
The post office failed to file a defence of the counterclaim by the deadline.
Yes.
And that was because of an error by a fee earner. We don't need to go into the details of it, but that was subsequently resolved.
Yes.
But the court had entered judgment in default of a defence being served, which led to your involvement in the case.
It did.
Let's have a look at a document then. It's poll 30070496, please. Could we go to page 2, please, right to the bottom? So that's an email from Stephen Dilly. He was an associate, was he, at the time in Bonpierce?
Yes.
And did he report to you?
Yes, on this case.
And we see there, this is it, to Bob Heckford on the 18th of November. Who was Bob Heckford?
I believe Bob Heckford was one of our internal risk people. I'm not absolutely sure, but I think that's the role he fulfilled.
So we see private, privileged and confidential, prepare for the purpose of a possible claim against the firm, and this goes on to set out the background which we've just discussed. We can see you're copied into it there. So against that background, could we turn to your email on page 1, please? Thank you. So 21st of November, you say that you've spoken to Mandy, that's Mandy Talbot.
Agreed.
What was your working relationship with Mandy Talbot at that point?
Solicitor client, cordial. Which aspect do you?
Well, how often did you work with her?
I can't remember, but sporadically, but regularly.
And what were your? You said cordial.
Yeah.
Was that saying it was is your evidence?
Yes.
It was a cordial
Yeah.
relationship. Yeah. You said I spoke to Mandy. She is understandably a little disturbed. Presumably that's by the default judgment.
She was angry.
And we've said already in your witness statement, you described Post Office Limited as a very significant client. Were you effectively being brought in to
Yeah.
calm Post Office's nerves?
Yes.
So it was being brought in to show that a partner was having clear oversight of this case.
Yes.
Would you usually have been brought into a debt claim such as this?
No.
If we go down, it's there already, sorry. See at number 2, it says Hugh James are currently trying to contain embryonic and not yet issued class action relating to the Horizon IT system. A judgment in relation to it, even in default, is currently very bad news for RM, presumably Royal Mail.
Royal Mail poll, at that time they were the same entity.
So breaking that down, Hugh James is another firm of solicitors.
Yes.
They are acting for Post Office in relation to what's described here as a potential class action.
Yes.
Can you recall what Mandy Talbot told you about this potential class action?
No, because it's 18, 19 years ago. I can go on if you want me to give you some colour.
Well, yes, what was your understanding of the scale of the action at this point?
I don't think I had an understanding at this point in time. What I think was going on here was Mandy was pretty peeved with the firm. We'd got a default judgment against them, which for £250,000, which is thoroughly bad news. Mandy, as I said, I did interact with Mandy periodically. I knew her reasonably well, and she could be quite forceful. And at this time, I think she was saying to me words to the effect of, "You've really stuffed up, there's an embryonic class action," to put fear into me and to tell me off. That's what I thought at this point, when this conversation took place. As time moved on, although I didn't know it at the time this conversation took place, I think she was overstating the embryonic class action, because as I understand it, it was in fact 2 cases, I think, and I think she was overstating the position to extract her ounce of flesh from the firm for having made a mistake, is what I think was going on, but I don't know that for certain.
But at this stage, there's a clear link being drawn between Mr. Castleton's case and an overall background worry of other cases relating to the integrity of the Horizon IT system.
Yes.
Could we... Yeah, it's there, actually, sorry. Point 1, under requests from Mandy, you say you feel we must comply with. The first one was that she's kept fully informed in this matter, including steps to be taken. I will lead on this. And 2, that she be sent a full set of proceedings in order and a full set of correspondence. And you go on to say, as you know, I would like a full set too, please. So you're envisaging a very hands-on role for yourself, it seems, in this case.
We need to get that default judgment set aside.
Was that... So that's getting the default judgment set aside. Was it also because of wider concerns about a class action that had been raised?
At this point, I mean, it's a long time ago, but knowing me as I know me, I would have been laser focused on the default judgment, the mistake the firm had made, and responding to the urgency that the client is putting upon me. And so my concern, my irritation that's coming across to my internal team here is saying we're going to get this default judgment set aside. That's what I think is going on.
Well, if we look at 3, it says, due to matters handled by Hugh James relating to Horizon, Mandy asks that we speak to them to ensure we are all pulling in the same direction. This is even more important given the threatened class action. It goes on to say 4 about not issuing proceedings in a claim based on Horizon evidence without her consent. And 5 wants a report on how many Horizon-based claims we currently handle. So it may be focus on the default judgment, but the class action was certainly playing a part in your mind and work going forward.
Yes.
At that point, did you or anyone at Bond Dickinson have a desire to become more involved in handling the wider potential class action?
I don't believe so, not at that point.
Could we look, please, at poll 30700480? This is an attendance note dated the 23rd of November 2005. We see on the left in the second tram lines, it says name Stephen Dilly. And it says, I had a telephone conference with Tom Beezer and Mandy Talbot. So this is Stephen Dilly's note of that.
Agreed.
Would you have seen that at the time or
No.
not? No.
I have seen it since.
Yeah. So at this stage, default judgment hadn't been set aside.
No.
And if you just read as much as you need, points 1 to 5, would you agree those are all about the substance of the case and not the default judgment?
No, I wouldn't agree with that. Because, do you want me to say why?
Yes, please do.
So the witness statements at 3, John Jones, Helen Hollingsworth and Kath Oglesby, were the set-aside witness statements, I think. We've got to remember we're going back 18 years here. I think those were the witness statements in support of the set-aside application. And so I think in these early stages... So the question was, do all 5 relate only to forward-facing actions in the case? The answer to that is no. I think some probably do.
So yeah, as I understand what you're saying is, admittedly it's with it is a long time ago, but presumably for the purpose of overcoming the merits test of setting aside a default judgment, rather than simply putting in a solicitor's witness statement.
Yeah.
Your evidence is that you're going to obtain witness evidence of fact
Yeah.
from the actual witnesses
Yes.
in the substantive case and serve that as
Yeah.
part of the part.
I think that's what's happened. If I'm wrong, I'm really sorry, but I think that's what's happened.
We then have point 6 about recommendations for counsel. Richard Morgan, now Richard Morgan KC, who we know came on
Yes.
to be counsel in this case. And at 7, referring to Mandy Talbot, and you say there that it's to attend a hearing on the 6th of December. Now, that's not a hearing for the default judgment application to be heard, was it? Because it was still being prepared at this point.
I don't know, but there is a file note on the file that I've read in preparing for this that hearing gets vacated.
Yes.
I don't know what it is. Maybe you do. I don't know.
And then as we carry on, if we go down, Mandy Talbot asked a question at the meeting on Friday is to ask whether rebooting of the system will change the cash accounts, and then asked for a copy of the expert reports. Would you accept that the conversation, I know you said this is about default judgment and preparation for default judgment, but it's all also forward-looking to the substance of the case as a whole?
Yes, I suspect. Yeah, I think I agree with you. But what I think is going on here is Mandy and me desperately trying to get up to speed. I think my first substantive involvement's on the 21st of November, I think, when I sent that note that you've shown me to the Bob Heckford after my first conversation with Mandy when she told me off. Mandy then says, I want a full set of papers. I say, I want the same. We've had a call with Stephen. I think it's certainly in part, and I probably would say in large part, about understanding what we can know with 2 days' worth of experience, of exposure to this case about the merits. At 3, we have the witness statements that I think are going to be prepared to support the set-aside application. And at 9, we're talking here about Mr. Castleton's expert reports. There was the Bentley Jennison one and the White Hoggett or something like that, that had come in September before my involvement, I believe, and they must have been mentioned on this call. And so Mandy is asking here for those expert reports that Mr. Castleton sent on a without prejudice basis. We didn't have any expert reports at this point. Yeah.
Before we turn the page, was it your usual practice in making out an application to set aside default judgment to lead witness evidence from the some or all of the witnesses you actually intended to call in the litigation, rather than simply rely on a solicitor's witness statement?
I'm going to say something that I don't mean to be jocular. I hope I don't have a usual practice in setting aside default judgments. But at this distance, I don't know. I just don't know. But this was our mistake, and me being the way I'm wired, the kitchen sink was going to go at this to get that default judgment set aside for what was an important client to our firm.
If we can turn the page, please. It says, Tom made it clear that we were to get counsel involved at an early stage as Bon Pierce were picking up the tab for rectifying the default judgment, and he wanted to go for a sledgehammer approach. Do you recall using the term a sledgehammer approach?
Not at all.
Is it wording you would use?
In that circumstance, probably.
What do you mean by that?
I mean, my firm has made a mistake, and as a partner of my firm, I'm going to get that mistake rectified.
Did the sledgehammer approach go to the overall conduct of the case, not just the default judgment?
Not at all. And I've pondered that, and I can answer that more fully if you'd like me to.
Please do.
We can see from later emails that maybe we will go to that after the default judgment is set aside, there is a definite pause and what shall we now do, both with Mandy and from the Bond Pierce side. So once the case is regularised, what shall we now do to take this forward? And so the sledgehammer approach or the kitchen sink approach isn't a comment about the action in general. And in fact, it's worth just remembering that in November 2005, Stephen Dilly had already suggested mediation to Mr. Castleton's lawyers. And in January 2006, before the default judgment was set aside, I think that's right in terms of timeline, a Part 36 offer had already been made. The offer of mediation was rejected the very next day by Mr. Castleton's lawyers back in November 2005. So there wasn't a set plan to have litigation here at all. There was a set plan in my mind to get rid of a default judgment, absolutely, yes. A sledgehammer, call it what you will. I was going to do everything that I could to rectify my firm's mistake for my client. But there was definitely post set aside of default judgment, which happened by consent, but quite late in the day. There was a step back and reflect, further attempts at settlement, and there was no desire for litigation.
Well, let's just look at this point. You're told at this point that there's a potential class action in the background. In your own words from the email before, default judgment was very bad news.
Very bad news.
I assume that at this stage, Post Office or Mandy Talbot was saying that the Horizon system was Mandy Talbot saying to you that there were any difficulties or problems with the Horizon IT system?
Not at all.
And presumably Post Office wished to defend any class action at this stage?
Yes, I assume.
And in this conference, it appears that you do touch on the merits of the case.
Yes, because we are collating evidence to put in support of the set-aside.
So standing back from all that, in that context, is it really your evidence that the sledgehammer approach was purely limited to the default judgment or to dealing with these Horizon claims generally?
But it is my evidence that it was purely limited to the default judgment. I'm absolutely sure of that.
Could we look at, please, poll 20119895. This is a document that was sent to you relatively recently by the inquiry.
It was.
It's a note of a meeting this inquiry seen on numerous occasions. My understanding is the attendance list, there's no one from Bond Pierce on that list. Is that correct?
That's what it shows to me. I hadn't seen this document before, and I hadn't seen it come up in the inquiry. It was a new document to me completely when you sent it to me.
Can you, appreciate at this distance, can you recall Mandy Talbot referring to a meeting such as this to discuss Post Office's approach to cases that involve challenges to the integrity of Horizon?
No.
If we turn to page 3, please. We see paragraph 14, there's a reference to Mr. Castleton's case, scheduled for the 7th of February. And your evidence is that you, at this stage, you weren't consulted in respect of Mr. Castleton's case about it being part of this broader strategy meeting.
No. This is, when is this, 2006?
2005, sorry.
2005.
6th of December 2005, so shortly after the conference note we just...
and so this is Mandy saying, on 7th February 2006, because the date is not there, is it? So because this is December 2005.
Yes, so it'll be...
So that must be something to do with...
I think it's a case management conference.
Was it? Or is it to do with the set-aside? Anyway,
But I suppose
nothing turns on it.
your evidence is you cannot recall being consulted about this matter.
No.
Thank you. Could we turn, please, to poll 30700910? So we're now, if you could turn to page 3, please. And yeah, that's perfect. Thank you. So now further on in the chronology, this is an email from Stephen Dilly to Mandy Talbot with you in copy on the 20th of February 2006. And if we look at number 1, it's the Post Office's view of pursuing the claim in light of the favourable evidence from John Jones, Kath Oglesby and Helen Rose, so pausing there, that those are witness statements in relation to Mr Castleton's case in particular.
And they were the ones in support of the set-aside application.
And that's being, Mr Dilly's view is that is in favour, in effect, of pursuing the claim against Mr Castleton.
Yes, he's saying... the inquiry has heard from Mr Dilly already, but my understanding from reading the file is his view of the merits of the case improved in the collation of the evidence for the set-aside. And what he's saying here is, in his view, there's favourable evidence from those 3 witness statements that was got in support of the set-aside application. So I think his view, my reading of the file, improved on the merits of the case.
It says balanced against balanced against any broader concerns over horizon issues. Is that talking about the potential class action?
I suppose the straight bat answer is I don't know what was in his mind, but that may be.
Well, I'm not asking you about what's in his mind. So let me rephrase it in another way. At this point, or reading this, would it, to you, suggest that on the one hand, there's the evidence in the case, which is suggesting pursue the claim.
Yes.
And on the other hand, balanced against that, or not pursuing it, are broader concerns over horizon issues.
Yeah, it says that, but I can't put that into context for you.
You can't recall, because obviously you were dealing with this case to provide reassurance to the Post Office.
Yes.
You presumably discussed it with Mandy Talbot since November and February.
Absolutely.
Can you recall being told anything about concerns about horizon issues, broader concerns about horizon issues, which would, in your view, lean the Post Office in favour of not pursuing Mr Castleton?
No. I know Mandy Talbot was concerned that there was a case that was an issued case that had a counterclaim for £250,000 that had a challenge to Horizon in the defence, and so that might be the broader concern. She was absolutely concerned about that, but that's against the background of my understanding and I believe Mandy's understanding that Horizon was robust, to use a word that we've heard many times.
I see. Can we turn to page 1 then, please? This is Stephen Dilly to Julian Summerhays on the 24th of February. And says, since the last email, I've spoken to Mandy to agree the strategy moving forward. Do you recall if you were involved in that conversation as well?
I don't know.
Says, internally, the Post Office feel conflicted about the Castleton case. The Post Office believes to be the Horizon system is robust, but the downside is the cost brackets in Post Office time and money of proving a negative, i.e. that there are no faults, is expensive. Goes on at 2. However, her view is that the Post Office must not show any weakness, and even if this case will cost a lot, there are broader issues at stake other than just Castleton's claim. If the Post Office are seen to compromise on Castleton, then the whole system will come crashing down, i.e. it will egg on other sub-postmasters to issue speculative claims. She knows that Castleton is talking to Bajaj, the other sub-postmaster, bringing a Horizon-based claim. Her clear message is that we must be seen to take a firm line. With this in mind, our instructions are as follows. Can you recall if at this point you thought there was a change in approach to Castleton based on wider concerns to do with Horizon? A change in approach from Post Office?
No. And so we'd tried to mediate in November. We'd issued the Part 36 in January 2006. And there were, absolutely right, Mandy had broader concerns, as is displayed quite clearly here. But once a case is issued, and once a counterclaim is issued, you can't get rid of it unless you settle it or unilaterally walk away.
So I think we took it at cross purposes. So in the first email from Stephen Dilly, we had on the one hand the evidence in the case from the witness statements was suggesting go ahead. And in his view, on the other hand, broader Horizon concerns saying try to settle it. And here we have an email saying, well, actually, number 2, the broader concerns is a reason to pursue the case, even if it costs a lot. Was that a change in position from Post Office?
I don't read it as that. There's sort of veins of thought that go through this difficult situation. We have some issued proceedings. You can't magic them out of existence. Unless you settle it, which of course needs consent of both parties, or unless you unilaterally discontinue, pay the costs, you're still left with the counterclaim of £250,000. This is a difficult situation that Post Office has become locked into. And in fact, if we read on, the very next step, with this in mind, our instructions are as follows. Please can you draft a Part 18 request? Now that Part 18 request was March 2006 and was, I think, completely directed at what is the problem, what's the defence, what is the allegation over Horizon? Because we didn't know, we wanted further information. We weren't trying to avoid engaging with that in any way. We actually wanted that information. So the very next thing Mandy says is, go and get information. Let's try and get some clarity here. We wanted to move this case forward. It's a problem. We as a firm have had a default judgment entered against our client. That's now sorted. That still lurks in this case as a sensitivity. There are issued proceedings. There's a vastly inflated counterclaim. What do? We've got to get rid of this. We've got to try and settle it.
If someone is trying to simply settle a case, just because for the reasons I think you said earlier, publicity or whatever it might be, you adopt a different litigation strategy to those types of cases than you do to, for example, a test case where you're trying to make a point irrespective of the cost. Would you accept that?
As a proposition, yes, I would accept that, I think.
So in this case, are we seeing here a change from your firm thinking this may be a case to settle to, well, now we're going to litigate it and treat it as a test case?
We tried to settle it throughout, all the way through. The inquiry has Stephen Dilly's long witness statement, and I can picture the table in it that sets out every attempt at settlement. Post Office wanted to settle this case. The counterclaim, the £250,000 counterclaim that sat there as a poison pill, was only stepped away from and dropped to about 11,000 on the 7th of November 2006. And that was about a month before trial. And so that was held on to all the way through, which created huge problems. How do we get rid of this? Mr. Castleton held on to that overinflated counterclaim, which I think actually sat in the hands of a company, really, if one looks at legal entities.
Well, we have your evidence on that. Let's look at how the strategy developed in those months in March. Could you look at poll 3071202, please? And could we turn to page 9? I think this is a hard copy document, which is why it's presented like this. But we see there's an email at the top left from Mandy Talbot. The date is 1st March 2006. There's Post Office addressees there, and then in the CC list, this has been sent to you and Stephen Dilly.
Yeah.
And it says, I write further to the meeting in December 2005, which most of us attended to bring you up to date with the current state of play. I think that refers to the meeting which, the note we showed earlier, but you weren't in attendance at.
No.
Do you recall receiving this email?
No, I don't think. I only saw this very recently when the inquiry sent it to me, so it's a new one to me, other than it was sent to me 18 years ago. I've only seen it recently.
Can we look at then page 6, please? So this is further on in the chain. See, it's been printed by Stephen Dilly at the top.
Yeah.
From Mandy Talbot to him and you. And if we go down, please, to where it says both. So I copied you into my epic email on 1st March 2006, but the response to the same has been limited in the extreme. Goes on to say, I have also been contacted by John Cole asking for assistance in preparing a spec for an external expert or experts. But I think that this is of limited use until we have reports completed by Fujitsu on the system and Post Office on the data provided. However, in respect of an external expert from the field of computer systems and accounting, can you suggest any names or firm who may be suitable? Can you recall at this time being involved or instructed by Post Office to find an expert to assist with Horizon claims generally, not just in relation to Mr. Castleton?
No.
Can we please bring up poll 3070850? So there's a conference note on the 7th of April 2006. You're in attendance, and Ian Herbert of Hugh James, the firm we heard from earlier,
Yes.
dealing with the embryonic, or was described as an embryonic class action. So was this conference as a to deal with strategy or consistent strategy on how to deal with Horizon-related claims?
I think this is the call that Mandy has asked the two firms to have. I think that's what's going on. What date is this?
7th of April 2006.
Mandy wanted there to be some interaction between the two firms in dealing with cases of a similar nature. That's absolutely right.
So it refers to a call, a discussion between you, Stephen Dilly, and Ian Herbert before Mandy Talbot joined. and it referred to Post Office having difficulty obtaining information from Fujitsu, and that the strategy should be to identify key individuals at Fujitsu who could provide the relevant information we require in terms of evidence, and then for Stephen Dilly of Bond Pierce and Ian Herbert of Hugh James to make an appointment to visit those individuals to take proofs of evidence. Each solicitor could prepare witness statements for their respective cases for Fujitsu to sign, thereby making it easy for them. In broad terms, was this proposition here to get evidence of fact from Fujitsu witnesses?
I'm not sure, because I think at the early stage of the Castleton case, and I'm going to class April as an early stage, I think there's a letter that Stephen wrote to Fujitsu in the early stages that suggests they might give an expert report. Now, with hindsight, that's misconceived because Fujitsu's too close to be an independent expert. And so...
We're just pausing there. So you say with hindsight, if you look at the fourth paragraph, it says Tom Beezer explained that if Fujitsu were not going to be put forward an expert, we would need to take Fujitsu through questions we have for them.
Okay, so I've already got there. They're not going to be an independent expert. Okay, that's right. But there had been a notion early in this case that Fujitsu could be a Part 35 expert, and I think that was misconceived, and I've clearly got to that place here. So yes, that must have been attending to get witness statements of fact from Fujitsu.
So the information we get from Fujitsu will not be an independent expert report. So we will need to obtain a separate independent report as well, but this will be easier if we have Fujitsu's evidence first, because then we will be able to focus the independent expert's report, which the Post Office will need to pay for, on relevant issues. And then it goes on to refer to more generic issues of a negotiation between Slaughter and May relating to the Horizon Online contract. Now, where you're talking about a separate independent expert report here, and it says we will need to obtain, is that across the board as a independent expert report, generic report going to the integrity of Horizon?
No, I don't believe that. That's a new concept on me. So with 18 years passing, it's hard to be absolutely definitive, but at no point have I ever thought we would get a one-size-fits-all. I don't believe I ever thought that. I think the we here in Stephen Dilly's note, remember it's his note, is us, Womble Bond, not a joint. I believe that's right.
Were you involved in, because you obviously had client care responsibilities and oversight,
yes.
Were you involved in discussing evidence in the Castleton case with any representatives of Fujitsu?
Me?
Yes.
No.
Were you involved in discussions with any representative of Fujitsu about the Horizon IT system generally?
Before preparing for this inquiry, I would have said no. I see from the file I did attend a meeting at Chambers, Council's Chambers, where Anne Chambers was present, and there must have been a discussion. But before preparing for this event, I would have denied that it even took place. So I've got no memory of it. I clearly met Anne Chambers once. I don't believe I ever spoke to anybody from Fujitsu at any other time.
And just on that, so I cover this off, I take it from your evidence that if I were to ask you any questions about a meeting with Anne Chambers, you would simply point me to the attendance note of that meeting.
I would.
Could we look at some of the draft actually, so looking at the time, it may be a good time to take our first morning break. So I think you're on mute still, sir, I think.
How much longer have we got on Mr. Castleton?
Not very long at all.
Well, let's finish Mr. Castleton, and then we'll have a break.
Of course. Could we please look at Pol 30 81490_008. There's a letter of the 5th of September 2006 to Stephen Dilly from Michael Mason of BDO, Stoy Hayward LLP, and they had been instructed to provide expert evidence, subsequently not relied on in the proceedings.
Yes.
Yes. Can we turn to page 3, please? And if we could go to the bottom, please. Under early indications of problems with the Horizon system, it says, we have found that there is some indication of possible problems with Horizon from our initial review of the electronic information you sent us. You sent the transaction summaries for January, February and March 2004. In theory, the system should reflect the double entry nature of each transaction, e.g. the system should show the sale of a stamp and the receipt of the cash paid by the customer. Therefore, the Horizon transaction entries for a period, whether day or month, should total 0. From our initial review, we can see that March balances, but January is out by £2.47 and February by £4.5. We have found which transactions cause the difference and will investigate them in due course. Although these are very small amounts, they do indicate that some problems may exist, i.e. that the double entry is not being put through. And you say in your witness statement that you were initially concerned by this.
Yes.
Why were you concerned?
Because if there is a problem with the system, that is concerning in the case.
These are small numbers.
Yes.
But the fact that Horizon wasn't adding transactions and the allegation appears to be that double entry accounting wasn't being put through, that's quite a significant issue for the Horizon integrity altogether, isn't it?
It would be.
Could we please look at Pol 30 69612? This is a note of a telephone call on the 6th of September 2006, so 2 days after that report's been received. Again, I understand this is Stephen Dilly's note.
Yes.
He refers to a conversation with you and says, also, Tom expressed his concern that the expert said that they found some early indications of possible problems, and it refers to the problem we've just described. It says, my comment to Tom is that I thought those amounts were quite small and that they will probably turn out to be a rational explanation because I've met with Fujitsu and they are utterly convinced of the integrity of their system, and really it's just an electronic calculator, so it's only as good as the person who inputs information into it. Did that assuage your concerns at the time?
To a degree. We've got to remember the 5th September letter 2006 from BDO was their initial letter. They hadn't done their work. They hadn't prepared a report. It was more than a passing comment, but it wasn't their concluded view. They had yet to do their work. And so in this case, as you may know if you've looked into the history of it, there were lots of blind alleys and lots of issues that were chased down unbelievably diligently by Stephen Dilly. For example, the Greg Booth screen freezing.
Well, let's focus on this one.
Yeah, for sure. But
and-
what I'm saying is we chased down issue after issue after issue. We were diligent and forensic. This was a comment from BDO before they'd done any work, and it's against that background that I would have been thinking about these things.
Well, let's assume this analogy or comparison with Horizon being an electronic calculator. Let's be favourable to Mr. Dilly and assume that's accurate. Would you agree that for an electronic calculator to be fit for purpose, it should be able to add up numbers accurately?
Yes.
And so the fact that addition errors were potentially found by BDO, Mr. Dilly's point about it being an electronic calculator doesn't really take anything anywhere, does it?
I think you're probably reading too much into an internal file note, but I agree with you, an electronic calculator would have to work.
If we look at the second paragraph, the third paragraph, it says, agreeing with Tom that the strategy should be that we pick up the phone to Lee Castleton solicitors, point out to them that Castleton has made an error analysing the cash account, tell them what our accountancy expert alone is going to cost, and invite them to ADR before we instruct an expert. Was this a strategy to try to dissuade Mr. Castleton from obtaining expert evidence on the basis of how much it would cost?
No, we wanted to understand the defence being put. There was a real desire to get information from Mr. Castleton. We'd Part 18'd in March 2006 on exactly that point to try and get information.
Well, let's focus here, though. You've received a letter an initial letter from an expert that raises potential problems, and the immediate response appears to be to raise the cost of the expert and go to ADR. Was it actually the strategy that you didn't want to dig any further into what BDO had found?
Not at all. Not at all.
Can we look at the draft report? This will be the last question we ask on this. Poll 3069955, please. This is a draft report dated 29th November 2006.
Yes.
Did you receive this?
Yes, I will have done.
Would you have reviewed it?
At a high level, given the circumstances and the imminence of the trial, but yes, I would have looked at it, yes.
Can we turn to page 18, please? And if we could go down to 6.2, we see addition errors, and it refers to the same addition errors as before.
It does.
And over the page, 624, I do not have an explanation for these errors, but my review of the transaction listings for the 3 months has given no indication of any other errors. Could we then go to page 4, please? And paragraph 2.1.2a, summarising the conclusion, the only indications of possible computer problems that are apparent from the accounting records are 3 very small differences in the cash account trial balance, but each less than £5. This is discussed in section 6.2. So you get the draft report in 29th of November, on the 29th of November, and this addition issue is still raised.
Yes.
So the problem's still there. It's possible, or it's at least raised, that Horizon in this case wasn't implementing double entry bookkeeping.
It's possible.
Did you discuss the BDO report with anyone at Post Office?
I don't remember, but I suspect the answer is yes.
Who would you have discussed it with?
Mandy Tolbert.
Anyone else?
I doubt it. No, I would have been speaking only to Mandy at this time.
Did you discuss the BDO report with anyone at Bond Pierce?
Stephen Dilly.
And after the Castleton case had come to an end, did you speak about the BDO report with anyone at Bond Pierce or Womble Bond Dickinson?
No. So that BDO report, just to give you some context around it, contained one huge glaring error that I knew about, which has become called the 3,500 point, that was a glaring error. And that BDO report was a draft report. It was dreadfully late. It was after all expert evidence has been debarred. It had a huge error in it, and it was 6 days before trial. There was no time to have the normal toing and froing that would happen on a draft expert report to bottom out issues. I simply don't know what would ever have happened to those small addition errors as to whether they would have remained in that report or not. But no work was done to find out because it was pointless. The report was privileged. There was no time to do it. I'd lost confidence in the report because it had a huge error in it already, the duplication error, the 3,500 point, and we were debarred by the order of Mr. Justice Seymour QC on the 27th of November, at which point we had still been wanting to try to get some expert evidence in. We were not running away from expert evidence at all. That expert report was meant to be in reply to something Mr. Castleton was meant to have served on the 10th of November. He never served it, although we know he had it because his solicitors told us on the 17th of November that he had an expert report, but they were not instructed to send it to us. And so that draft document was meant to be sequential. It was never meant to be a standalone document. It was late, it was debarred, it was wrong. I know it was wrong in huge degree. And so it was debarred. We couldn't use it.
You said you know it was wrong in huge degree. You're referring to a point about £3,500 and a trial and a balance snapshot.
Something like that, yes.
You didn't know that the addition errors raised was that their position.
No, we didn't. But there was no time to bottom out those kind of issues as you would do with any normal expert report.
And at this stage,
yeah.
You were aware that Post Office was relying on Horizon data for civil and criminal claims?
Yes. Well, certainly civil. I don't know what they were doing in criminal claims.
You were aware that there were other cases where sub-postmasters were challenging the integrity of the Horizon IT system?
At a high level. I mean, I knew of them. I didn't know any detail.
You had a report that raised a potential issue with double entry bookkeeping in the Horizon IT system?
Yes, but for all the reasons I've just been through, it wasn't one we were confident in.
But on the addition error, you couldn't say that that was an incorrect opinion?
Nor could I say it was correct, but yes, I agree with you.
Do you accept that it was incumbent on you to advise the Post Office to investigate that issue further because there were other... It would have started a train of inquiry as to whether the Horizon IT system lacked integrity?
I don't know that I didn't say that. I don't remember. I will have discussed it with Mandy.
Let me ask you, is your evidence that you did advise that, or can you not remember?
I just don't know.
So that's a good time to break, and we'll move on to the recusal next.
Right, thank you very much. I make it 11:05. Do we need to be as limited as 10 minutes, given that we've just got one topic to cover before? What's the timetable, Mr. Stevens? Is Mr. Lenton coming this afternoon, or is he available before that, so to speak?
I understand he's available before that.
Right, I see.
So I'm happy. I'm in your hands, sir. I'm happy to take 10 minutes or happy to take 15, whichever you prefer. But I don't think we're pressed for time.
Right, so let's take 15 minutes, but it's on the basis that we might jiggle the days, so to speak. We'll take 15 minutes, and then if we complete Mr. Beezer before 1 o'clock. We'll make a decision about whether we start Mr. Lenton or have an early lunch then. All right?
Yes, sounds good. Thank you, sir. Good morning, sir.
Morning.
On timetabling, I anticipate that we'll finish well in advance of 1 o'clock. Whether
Yeah.
we have an early lunch or plough straight on, I think we'll need to decide when the evidence is finished. I've spoken to Ms. Hodge, and there's a couple of logistical matters that need to be seen
Yep.
to. Perfect.
Whatever, Mr. Stevens. All I'm indicating is my willingness to be flexible in the way we deal with these things.
Thank you, sir. I will carry on then. I want to turn to the recusal application. And at this point, I'm going to make a point, almost word for word, that was made by Mr. Beer yesterday. The authoritative legal position in relation to the issues addressed in the group litigation are set out in the judgments of Mr. Justice Fraser. It's now Lord Justice Fraser, but for historical purposes, I'll refer to Mr. Justice Fraser. So for the purpose of your evidence, those judgments include the common issues judgment on the 15th of March 2019, the recusal judgment 9th of April 2019, and insofar as relevant, the Court of Appeal's decisions refusing permission to appeal those. I'm not going to be exploring the factual legal position definitively established in Mr. Justice Fraser and the Court of Appeal's judgment.
Understood.
You say in your witness statement that you were broadly aware of the GLO proceedings, but that you didn't have any material involvement until the recusal application.
Yes.
Now, this was Andrew Parsons' case, effectively, wasn't it? The GLO proceedings.
Yes.
You hesitate there. Why wasn't it Andrew Parsons' case as solicitor?
Yes, it was, but there were other people involved. The run into the GLO was took some time, and there were other people involved. So was Andrew Parsons the lead person? Yes, I think he was. If that's the question.
He was. Yes, he was the partner over his responsibility for
right.
the conduct of the case.
Yes. Sorry, I was talking about a different issue.
In terms of the management structure of Womblebond Dickinson, during the currency of the group litigation, where did Mr. Parsons sit in relation to you?
So the group litigation started in 2016?
He did, yes.
Yeah, so I was a partner in the Southampton office. I was the team leader of the commercial disputes team, and he was a partner in the commercial disputes team.
Did you have any oversight of Andrew Parsons' work at this stage?
Not his work. I mean, I had oversight of the team and the things going on in the team, but day-to-day work, no. Concern over day-to-day work, yes, absolutely. So I'm not using that answer to try and step away from anything, but would I check another partner's work? No.
For background, Mr. Justice Fraser distributed a draft judgment in common issues on the 8th of March 2019.
8th March, yes.
The Horizon Issues trial was due to start on the 11th of March 2019.
Agreed.
What had you heard from members of the Womblebond Dickinson who worked on the GLO about how the GLO proceedings were going, in effect, prior to the common issues draft judgment being distributed?
I had heard positives. Yeah, I was going to say positive signs. You can't hear a positive sign. The mood music was okay. It wasn't. If the question you're asking is from a management perspective, was this a case that was flagging up as a difficulty pre-common issues draft judgment? It was not, and so the judgment was a huge surprise to the internal team at Womblebond. So the mood music about the common issues trial pre-8th March was not negative.
And no concerns have been, I take it from that, no concerns have been raised with you about the impartiality, apparent or otherwise, of the judge before 8th of March?
No.
In your second witness statement, we don't need to have it up, but it's page 5, paragraph 9. You say, I understood from the Womblebond Dickinson GLO team that the draft common issues trial judgment was very unfavourable to Post Office, that the Womblebond Dickinson team and Post Office were dismayed by the outcome, and that there was talk of a possible urgent appeal. Who within Womblebond Dickinson told you about the common issues trial judgment?
It would have been Andrew Parsons, Amy Prime, those kind of people. I can kind of picture them sitting the judgment on their knees, turning the pages, getting more and more distraught, as it were. So I can picture that. So
what did they say to you?
Oh, I don't know. I don't know in detail. This isn't good. He's got that wrong. Oh my God. Those kind of comments. But those aren't verbatim quotes.
And when was the first time you were aware of the proposition to issue or potentially issue an application for an order that the judge recused himself?
So it was either the 11th or 12th of March, but which one I don't know. I was provided some papers on the 11th of March. I think in that tranche of papers was the David Cavender note of the 10th of March, I think. And I think that included a paragraph on recusal. And so I'm going to say 11th March.
I think in your witness statement, you say from, we don't need to have it up, but paragraph 14, page 7, to the best of your understanding, the idea of recusal came from David Cavender, KC.
I think that's right. There's an email of the 9th of March where I think it's first raised by him. I'm not copied in on that. I'm not involved at that stage. But that, to my knowledge, that's the first time in this matter, reading in and preparing for this inquiry, that's the first time I've seen that the recusal is mentioned.
And you were brought in to assist on the recusal application because the rest of the GLO team in Womblebond Dickinson were preparing for the Horizon Issues trial. Is that right?
Yes, not all of them. Some were preparing, some were working on the further issues trial. So a nucleus of the Womblebond Dickinson team absolutely was preparing for the Horizon, because the 8th of March was a Friday. There was an intervening weekend. The 11th was the Monday when Horizon Issues Trial started, so there was no time at all in which to do anything, hence me being brought in as a senior person in a point of difficulty for the client with a judgment that's gone against them.
To what extent, if at all, do you think your lack of familiarity with the GLO proceedings limited your ability to advise on the recusal application?
It must be a factor. I did not have familiarity with the GLO proceedings. That's absolutely right. Was it an impediment? With what I was asked to do rapidly, which is to get independent advice, it was not an impediment to carrying out that instruction. As I got more up to speed, I think comment was passed and advice was given, although I have to say the client was not after our advice, Womblebond's advice, my advice. They did not want that advice. They wanted new voices. You would have seen from the file the phrase new voices comes up quite a lot in independent advice. So it must be an impediment on hour zero because I know nothing about it. But as we go forward over the intense few days, I knew more. In any event, what the client wanted from me was organisation and logistics to get it independent advice from, as it turned out, Lord Newberger, then Lord Grabiner.
I want to look at some of your early conversations with Jane McLeod in organising the recusal application. Can we look at a conversation you had with her on the 12th of March 2019? And I want to bring up your handwritten note and your transcript of it, just for ease.
Yeah.
So can we have up at the same time, please, WBON 301734. And also WBON 301735. Now, this is the first time we'll see a few of these. We see it's a handwritten note. This is taken from a notebook of yours, and there are parts which are covered out in yellow, which are redacted, and the inquiry understands that those have been redacted for either privilege or relevance reasons.
Agreed.
So,
And the redaction, I should say, is nothing to do with Post Office. It'll be other clients, so none of the redactions at all relate to Post Office, just so that's an issue we cover off.
we see there 12th of March 2019, it says J. McLeod and then a redacted bit. Further down, we then get your note which says Newb equals insight, presuming Newberger
Yes.
equals insight, only 2 days off SA, and this is presumably the note you took of the conversation at the time.
It'll be scribbled notes. It's not verbatim. It's scribbled notes. Obviously, this was done out of habit as a lawyer. This isn't a verbatim note, but yes, these are my notes of that conversation.
And was this the first conversation you had with J. McLeod?
There might have been an earlier one. If you tell me this is the first one, I'll say yes to that. But I can picture one in blue ink that says in-depth advice. I thought that was the first conversation. But if you tell me this is a later one.
Well, let me because we'll come to another note.
Yeah.
Let me rephrase my question. Was on the 12th of March.
Yeah.
Was that the first time you'd had some material conversation with J.
Must have been. I got documents on the 11th. I was reading in on the 11th, trying to get up to speed. And the 12th is when I suspect I began to interact with Jane.
And can you recall on this conversation, we're talking about the instructing counsel.
Yes.
What if anything, did J. McLeod say about her view of whether the Post Office should bring a recusal application at this stage?
I think they were interested in the concept of an application, but trepidatious. That's reconstructing what I think was going on. This is some good few years ago now. It was a topic that had to be investigated if there was legal purpose in doing it. That's my impression.
Did, at this stage, J. McLeod say anything about Post Office's motivation in investigating the recusal application?
I don't know if it was in this conversation, but my impression, one of the main planks of their motivation, I think, was to get to a legally correct common issues judgment. That's what I think was going on. Whether that was said in this conversation or in later conversations, I don't know, but that's my impression of their motivations.
So we'll come to the later conversations, but
Yeah.
just taking that there, on what basis did you form that impression from why that was J. McLeod's motive?
Because, I suppose, and this is me reconstructing, so on the 11th I'm reading in, there are two topics knocking around. They're intertwined, but not necessarily intertwined, being appeal of common issues judgment and recusal. And the interconnection with those two topics is large parts of the common issues judgment was perceived to be wrong and perceived to be the judge, as we've heard from Lord Grabbanner, had gone too far, the apparent bias point. And so in any early conversations with Jane, I must be talking about why we're doing any of this, and why we're on this journey, to look at appealing, to look at recusing the judge.
You So then, Neuberger equals insight, only 2 days off SA, and then it says can assist but not be briefed in person. What does that mean, can assist but not be briefed in person?
He either had gone or was about to go, I don't know, to what we now know to be South America, Argentina, but I think at times we thought it meant South Africa.
So that's referring to a whether or not he could attend in person.
Yes.
Yeah.
Yes.
Thank you.
Yeah, face to face.
Could we please then turn to WBON 301739? So this is your email to Andrew Parsons and Amy Prime on the 12th of March at 8:23. You referred to a good chat with GC Jane, and just to timing it, we see the third para down. It says issue I raise is inability to brief NQC, presumably that's Lord Neuberger.
Yes.
In person. So do I take it that this email follows the note that we just saw then?
Yes, yes.
And it says, think she begins to agree, grab.
Yeah.
Is that referring to Lord Grabban?
It is.
When you say think she begins to agree, what is that referring to?
Instructing Lord Grabiner.
That reads almost like she needed to be persuaded into it, or she had a view and, begins to agree to the instruction of Lord Grabiner. Why is it written in that way?
What I think is going on here is this is on day 2 of my involvement. I'm knowing how I'm wired. I'm perceiving urgency. If you're going to do something like a recusal, you've got to get on with it, especially with the Horizon Issues trial underway. This is urgent, and I remember being frustrated that I simply wanted to know who we were instructing and to get on with it. And there was prevarication about who to instruct, and I remember being really quite frustrated by that. And I wanted, personally, to instruct, and we might come on to these topics later, the advocate who could do the advocacy, the barrister who could do the advocacy. This two-staged approach, whilst with hindsight makes sense, at the time it frustrated me because it's a time impediment as to what I see as being urgent. So
you, just to be sure I've got your evidence right on this, this is, your frustration is a decision on who to instruct. Was there any hesitancy from Ms MacLeod at this time as to whether or not Post Office should even investigate the recusal application?
No, I don't believe so. I don't believe so. There wasn't a dead set plan to do it. The board were nervous, but there was, I felt, some prevarication as to who to instruct, and I just wanted to get on with it. To find out what the independent advice would say, yes, no. And so there wasn't a concrete plan of any sort at this point.
Okay, could we then turn, please, to WBON 301745? Unfortunately, you've got a typed version. WBON 301747 on the same screen, please. So this is a note on the 14th of March 2019. I'm going to work from the left one. It says Jane and DCQC call. So that's Jay McLeod and David Cavender.
Agreed.
Where it says CC Gideon, is that referring to Gideon Cohen?
Yes, but I don't know what the CC means, because obviously this isn't a letter. So I don't know if he was there or not. I've no idea.
And briefly looking at the document on the right, we have black pen and then blue pen. The blue pen is sort of fit around the text that's already been written in the black. Are both entries made by you?
Yes.
And presumably the blue pen is made later?
Maybe not. I have many pens, a slight fascination of mine, and multiple colours are habitual, and changing pen is a habit. So I can't say that didn't happen on that call.
Fine. If we look down, I'm looking at the left again, we see halfway down, 2 bullet points that says had LN note. So that's referring to Lord Newburger's note of advice, I assume.
Yes.
So the call happens after that.
Yes.
It says then stages. 1, what does Paul want to do? And 3, Post Office Limited not able to make a decision by 12 tomorrow.
Yes.
At this call, do you recall whether there was any discussion of what the Post Office directors thought about whether or not they should bring an application for recusal?
At this point, no. But this, you will see that this builds into the narrative that I'm frustrated. What do you want to do? So.
What was it? Did you have any impression at this stage of the board's position?
14th? No, I don't think I would have done.
If we could go further down, please. Thank you. So at the bottom, it says board call. So presumably that's referring to the need to set up a board call.
It will have been, yes.
Now, help us with how this is structured, because we've got a second bullet point saying real, possibly, board to speak, Newburger, possible outcomes.
Yeah.
Does that mean there's a real possibility that the board want to speak to Lord Newburger about his advice?
I suspect this is Jane speaking, saying, well, to take this forward, we're going to have a board, Pol will have to have a board call. Pol will need to take this issue to the government, but that's little number 2. And there's a real possibility Pol's board will want to speak to Lord Newburger about possible outcomes. So my impression as I sit here now is that's me capturing what Jane is saying.
Okay. What was said at this stage, if you can recall, about government's involvement in the decision to of whether or not to issue the recusal application?
I think at this stage, Jane is saying, I will need to get the government involved. I think that's all that's going on at this stage. This is the 14th, yeah.
14th, yes. Yeah. We'll look at the next day now, please. WBON 301749. And at the same time, could we have WBON 301752, please? So we have, assuming that means telephone call in from Jane.
Yeah. She's called me.
She's called you.
Yes.
And it records, I assume what she said, Tom Cooper, chairman, setting up board call for Monday night.
Yes.
Board to form a view.
Yes.
Was anything else, do you recall whether anything else was said about at that stage on the board's view or individual directors' views?
No, this is me, I think probably in that way lawyers do, jotting down bits of information as they're given. This is Jane speaking to me, telling me things, and I'm scribbling them down out of habit.
it says Tom C, so that's Tom Cooper.
Yes,
So Tom Cooper was a UK GI official,
I believe so.
and he was the non-executive director appointed to represent the government's shareholding interest.
I believe so.
So it says Tom Cooper will struggle to get this through shareholder. Now, in that, shareholder means government.
I think so, yes.
Do you recall what Jane McLeod said to you that led you to make this note?
I think that's what she would have said. This is me scribbling down. I will not have really known at this point who Tom Cooper was. I probably, had I turned my mind to it, would have understood the ownership structure. But this is Jane saying things to me and me writing them down.
You said that you were, I think frustrated was the words you used. It may not have been, but it conveyed that meaning.
Yes.
Getting a decision.
Yes.
This presumably then wasn't welcome news if there's going to be a difficulty to get it through the shareholder.
It's only unwelcome news if you're going to go for it. If you're not going to go for it, it doesn't matter either way.
Did you inquire as to why she formed that view that Tom Cooper would struggle to get it through the shareholder?
No. The post office relations with the government and its shareholder being the government were something I didn't get involved in. We never had substantive discussions about that beyond these kind of, I suppose, why is she telling me this? I suppose it's a timing conversation, this, isn't it? This is all about timing.
And then it seems it refers to a brief note over the weekend. That's a note to the board that you assisted in preparing to explain.
She is asking us. It became called. She wanted a plain English note, I think she called it. So I think Jane is saying to me, I'm going to need a note over the weekend for the board, and that's indeed what happened. So this is about timing and steps on the way.
I want to just cover the timing of the note a bit because I think it's relevant to understanding how that note was formed and what your instructions were. Could we look, please, at WBON 301499 and page 4, please? Thank you. If we could go down the page slightly. Thank you. So your email to David Cavender and Andrew Parsons is included in copy. See attached. I may be on Jane's wavelengths, I may not be. And this is attaching your initial draft of that note that she asked for. You said be as harsh as you like.
Yeah.
So you're inviting comments, basically.
Yes.
If you go to the bottom of page 3, please.
And I'm inviting comments because I'm aware of my paucity of information and background on this. So I've broken the back of, everybody's busy, I've broken the back of this task and got something down on paper and got it out to people to finesse.
It says, then it's Andrew Parsons' email to you. He attaches another version. I said, did Jane want us to offer a recommendation on whether to do this or not? It seems like we are sitting on the fence slightly, but sometimes she prefers that. If we then go up to your response, so just for timing, that was Andrew Parsons sent at 10 to midnight on the 15th. Your response is just before 4 o'clock in the morning.
It was a busy time.
16th. You refer to the drafting and then you say, as to recommendations, I'm unsure. My current feeling is we simply set matters out and then let Post Office Board discuss rather than pushing them one way, which the note already does, to be fair, as it has to, as we have to point out the inconsistency risk, etc. As we know, there are competing views around the board, so I don't want us looking fully partisan. At that stage, what were you aware of the competing views around the board?
I don't remember, and so reading this, I must have known something to write it. I cannot recall what I knew about competing views. I just don't know.
Can you assist with this? And if this is a fair reading of that email, what you appear to be saying there is your current feeling was not to expressly set out,
Yep.
we recommend you do this,
Yep.
but your view was the substance of the note as
Yep.
drafted,
Yep.
push them in in a direction to recuse anyway.
Yes, because we mentioned earlier the interconnection between the appeal on the law of the common issues judgment and the connection with recusal, which is driven by the procedural unfairness point. And so if they were going to go forward with a head of appeal based on procedural unfairness, for reasons we might not need to go into, but you'll be aware of, that there had to be, or it was felt at the time, there had to be an application to recuse. And so that's what I mean by the inconsistency point. If you appeal on procedural unfairness, but don't try and recuse, the Court of Appeal may later say, well, that's an inconsistent position to adopt. That's what the inconsistency phrase is there. And I'm saying, because I know that Jane wants independent advice, I know that she doesn't want our advice, hence me drafting a neutral note, but it does have to push them one way, because if they do want to go down the route of procedural unfairness, it's inevitable that you have to promote the concept of a recusal.
If you could turn to page 1, please. So this is David Cavender's email to you and Andrew Parsons. It's at 11:05 on the 16th of March. And the final substantive paragraph says, on the issue of giving... Oh, no, sorry, before I ask that, had you spoken to Jane on the telephone, not in email, to Jane McLeod in between your email of just before 4 o'clock on the 16th of March and David Cavender's email?
I've no idea. If we don't have a note, I have no idea.
So Mr. Cavender says, on the issue of giving Post Office a steer, I understand the sensitivity, but it should be, I think, that advisors should advise and not simply leave it to the board to come up to their own untutored view. Surely we should be setting out the options but making our recommendation. We can go to the documents if you wish, but as I understand it, that advice was accepted, and the note sent following that said that Mr. Cavender and Womblebond Dickinson recommended that the application be made as soon as possible.
Yes.
So you accepted that advice from Mr. Cavender effectively?
Yes, and the amendments to the document were taken in and sent to Jane in markup so she could see who'd done what.
Could we please turn to poll 3022969? And if we could turn to page 4, please. So we have here an email from Jane McLeod, 16th of March 2019 to you and Andrew Parsons. So this is just before, I think it might have 10 minutes or so before Mr. Cavender's email.
Oh, yeah, okay, yeah.
And it says, many thanks, refers to a call with the chairman, Al Cameron, and the minister, Kelly Tolhurst MP. Although I don't believe recusal will be part of our discussion. I have been advised by the UK GI General Council that government will not express an opinion on recusal, as they will not want the executive to be seen as criticising the judiciary. This will put more pressure on our board, and the chairman is acutely conscious that such an application will not sit well with the perception that Post Office is arrogant, whereas we are trying to edge towards contrition. The effect of that is we need to be very clear what the risks will be of not proceeding with the application, and goes on to set out what she wants.
Yes.
Had you communicated the content of that email to David Cavender before he sent his email recommending that a position should be taken on how to advise?
I don't know is the straight bat answer. If the file doesn't show I did, I simply don't know. It's the kind of information I would have circulated, but I'm unsure as to the timing.
Were you can we move on actually, please, to poll 20330036? If we go down, thank you. So it says this is an email later on that day. It would be helpful to have a call on this, and in particular to understand whether Lord Grabban has formed any views on this yet, and if so, what they are. The board is highly nervous of this strategy. Our chairman has already said to our minister that while he recognises that the board has a fiduciary duty to act in the best interests of the company, he feels it is unlikely that they would want to adopt this course of action. Just pausing there, the talk of fiduciary duty, had there been any discussion of there being a fiduciary duty on the company, on the directors to act prior to this being raised?
At that point. Because I know it came up later, forcefully, from Lord Grabban.
Well, I want to come to that in due course.
I don't know if it had come up already. I don't recall.
So we're very clear on both why doing it is in the best course of action and what our prospects of success are. And you said, Jane, I'll call in 20 minutes. Now, you recently and helpfully provided another note,
yes,
which I want to go to now.
Yes.
For our co-participants, it won't be on CP View yet. It was very recently provided. That's no criticism, but can we turn, please, to WBON 301899, please? And the typed version that you've created, WBON 301900. Is this a note of the call that we were referring to in the email just now?
I suspect so, but I don't time these scribbles, so I'm sorry. But I suspect it may well be.
Do you recall what, if anything, Jane McLeod said about the board or the chair's concerns about the recusal application?
No, other than, as I've said, they were trepidatious about, they were nervous about making it.
Do you recall if anything was said about government's position on the recusal, the government's position on the recusal application?
Beyond the emails that we've seen saying that they would be neutral, no.
Please, could we, it's either scroll down or turn over the page. I don't have a
I think copy, it's scroll down on my note.
Is there a second page to that? Yeah. Thank you. So it says here, big picture, presumably.
Big picture, yes.
Told Jane to Jane. What does that mean?
If we can get the handwritten one up, I might.
Yeah, of course. It's on the right. If you could turn to page 2, please.
Told Jane. So I suspect they're two different blocks of conversation. Told Jane, and to Jane, loss all the way through. So I think they're bits of different jottings, if you see what I mean. So it's not one sentence that says told Jane to Jane.
I see. So it might be, would it be told Jane PRV trial?
Yeah, and to Jane, loss all the way through. I think that if you can sort of draw a line mentally down the centre of the page, in that part anyway.
Okay. So you said PR set against trial, loss all the way through.
Yeah.
If not recuse.
Yeah.
So is this what you were saying, you were advising or telling Jane MacLeod?
By this stage, we'd had the Lord Newberger note, I believe, on the 14th. We were developing our note that became the note of the 17th. And there was a process of mutual drafting with Andrew, David Cavender and Jane herself. And there was the view that if the judge remained in place, there was risk to the coming trials due to the view of apparent bias and entrenched views.
So it then says, high tempo step, Jane warned.
Yep.
What does that mean?
So that's me. So there, and if you recall the red ink note that we saw earlier, that also had the PR bit in it. So this is my shorthand to myself. I'm warning Jane about the risk of, in doing this, this is a really aggressive step, Jane. The PR of doing this. So it's a high tempo step. I've never done this. I've never had cause to do this in my whole career, Jane. This is an unusual step to take. It's high tempo. That's me warning Jane.
And at this stage, what was your impression of Jane MacLeod's view of whether or not to pursue the recusal application?
I think she was, well, I know she was seeking independent views. To be blunt, she couldn't care what I thought. She wanted the views of Lord Newberger and Lord Grabiner, or whoever we went on to instruct. By that time, we had decided on Lord Grabiner. And she wanted information in from those people. So even our note that was drafted between the 15th and the 17th, what she really wanted was what's Lord Grabiner's view on that note. That's all she wanted.
Well, I'm going to turn now to a conference with Lord Grabiner. Now, you set out your recollection of that conference in your statement. You've exhibited typed and handwritten notes.
Yes.
We heard from Lord Grabiner yesterday. I don't propose to deal with lengthy issues on that. I want to cover 2 points briefly. Could we please have Poll 406397? So this is a note of a conference on the 18th of March 2019, and then this is the version that's updated to include the 20th of March board dial-in as well.
Yes, Jane wanted a compendium note, as it were, in the end.
Could we turn to page 2, please? Thank you. So we have the duty to act. So Lord Grabiner explained that in his view, if there's no recusal application made, then Post Office will lose the series of trials set up in this matter. Without a recusal application, Post Office is stuck with this judge. An appeal on the law may correct some of the significant errors in the common issues trial judgment, but then the case will be sent back to this judge who has demonstrable apparent bias against Post Office, and hence the firm conclusion that Post Office will lose and the financial impact of that will be substantial. Recusal is therefore essential, and Lord Grabiner asserted that in the face of legal advice from Lord Newberger, that recusal should be applied for and the quantum of damages that Post Office will pay out on a loss. Then it was Lord Grabiner's view that there was a duty on Post Office to seek recusal. What did you understand from that point, that there was a duty on Post Office to seek recusal?
To act in the best interests of the company is what I think I will have taken at that point from that word duty to act.
was your understanding of the advice given by Lord Grabiner that there was a legal duty to apply for recusal or something else?
I don't know, and I don't know how hard I would have turned my mind to that question. Duty to act in the best interests, did that tip over into the legal meaning of that in that conference? I don't know. I don't know.
Can you tell me, Mr. Beezer, this note is on Womblebond Dickinson note paper.
Yes.
Someone obviously composed it. Do you know who actually composed this minute or note?
Me.
It was you, right?
It was,
fine.
absolutely, it was me. Yes, yes.
So we have on the documents a series of emails of it being amended.
Yeah,
which we can
that's fine. I just
provide.
wanted to have it clear in my mind while we were discussing it, that's all.
Yeah.
Thank you, sir.
And so this, whilst not absolutely verbatim, it will be not far off. And the inquiry has the contemporaneous handwritten note that I produced this from.
Yeah.
I want to turn to that now for a second point. Could we please bring up WBON 301776? And if we could go, it was say, sorry, I should orientate ourselves. So could we also get up WBON 301737? So we see this is referring to the handwritten note of the conference call you were
Yes.
just referring to. Could we please go to page 5 of both notes? Thank you. And you see on there's a towards the bottom, Jane underlined. That's Jane McLeod, isn't it?
Yes.
I read this as, tell me if I'm wrong, instructions to prepare on basis that the recusal application will go ahead.
Yes.
And then it says need to get board over line.
Yes.
What did Jane McLeod say that led you to make that note?
That's what she will have said. I mean, that is what she would have said. But I will need to get the board over the line. There's going to be a board call today, and we're going to schedule a board call for next Monday. And so that's what she said.
So at this stage, was it Jane McLeod's position that the right decision was to issue the recusal?
No. Okay, I understand what you're asking. So she was saying, because I'm saying it's urgent, Jane. We're waiting. This is, it's annoying me. So she's saying, okay, press on, draft, do your stuff, lawyers, as if we're going to go. I still need to get the board over the line. And so we are preparing as if we're going to, or more to the point, the council team is preparing as if it is going to go. She is going to need to still get the board over the line.
So at this stage, did you have any impression of what Jane McLeod thought of the merits of the recusal application?
No, I don't think I did. What she thought personally?
Yes.
I don't think I did.
And your evidence is that wasn't discussed in this conference?
No, if this note doesn't... I mean, whilst this is not an absolutely verbatim note, I would have tried to capture the salient points. So no, I don't think so.
I want to ask one brief question on the call on the 20th of March 2019. If you want to see the note, we can bring it up. As the note reads, it appears that you and Lord Grabiner attended the call. Lord Grabiner gave advice, and then you and Lord Grabiner left the call.
Yes, that's exactly what happened.
From that call on the 20th of March 2019, did you get any impression of any of the directors' views on the merits of the recusal application or whether it should be brought?
No, it was. No, there wasn't free-flowing discussion at all. As the handwritten contemporaneous note will probably sort of give you the impression, Lord Grabbanner said his bit. There were 3 or 4 questions from unknown voices, unknown to me at the time. So the board asked, is there a middle way? I don't know who. And then we left the call. And so Lord Grabbanner and I were not there for any of the, what I assume must have followed as being discursive, should we do it, shouldn't we do it? We weren't there for any of that. If that in fact occurred, I wasn't there, I don't know.
Last document, well, 2 documents from me. It's, please can we bring up WBON 301792. And at the same time, please, WBON 301795. So on the handwritten note, we say it says 20th of March 2019.
Yes.
There's a 17 on the typed copy. Is that an error?
Yeah, that shouldn't be there. I think that's someone putting a page number on, isn't it?
Fine. So
Yes, sorry about that.
no need to apologise. Just so we're clear, it's 20th of March 2019.
Yeah.
It says Jane, and then quotes go. Is that go on the recusal application?
Yes.
And then we get this, uncomfortable regarding tone in judgment.
Yes.
Board really uncomfortable. What did Jane McLeod say to you that led to that note?
I mean, it's probably exactly what, this is my scribbles during a phone call. And so that is what she will have said. She'll have said, the board's really uncomfortable, they're really sensitive around tone. You've got to tell the council team, I don't want any high tempo language, I want calm. So that's what she will have been saying to me in that call.
So what was she saying the board were uncomfortable about? Was it the language or the making of the application itself?
Retone in judgment. So no, the board is uncomfortable with how Post Office is portrayed as aggressive in the common issues judgment. And she's saying, I want these documents that support any recusal and any witness statement to be calm. So the uncomfortable is how the Post Office is portrayed in the common issues judgment. That's what's going on here.
Did Jane McLeod say to you anything else about her view on the application itself?
I don't think she did. And since you asked that question, I've been pondering. I don't think I ever knew what Jane's own position on it was.
At this point, did you have any understanding of what the board's motivation was in making the application?
My understanding of why Post Office wanted to do this is about the desire to get a legally correct judgment in common issues, the desire to avoid what seemed to be a near inevitable series of losses of trials going forward. They were the motivations, and I can only speak from my impression that I got from Jane, because that's the only person I really interacted with substantively on any of this. And all of those motivations seemed, based on the understanding that we had at the time, proper.
To what extent, if at all, was there any discussion when concerning the recusal application that it should be made to put pressure on the claimants or the litigation funders?
Not at all, from within my visibility, not at all. Yeah, not at all.
So, I've just been handed a note. That may be the end of my questions, but if I may just have a moment to discuss
Yes,
it
of
with Ms.
course.
Price. Thank you.
Yeah.
So there's no further questions from me, but I will just check the room to see if there's one issue. Ms. Page has asked for one issue to be dealt with. No. Do you have a time? Ms. Page has asked for 5 minutes, sir.
Well, I'm sure that we can accommodate that.
Thank you, sir.
Thank you. Mr. Beezer, I'm going to ask you about a particular note which is to do with the relationship between the Bates litigation and the criminal appeals. If I could ask, please, to bring up WBON 301511. And if we go to page 4, as far as I've been able to work out, the blue typing is you chipping into these emails.
That's right, yes.
There's this paragraph in the middle. It reads, also on the topic of settlement, it is necessary to remember that 30 out of the 557 claimants have been convicted for shortfalls. Those 30 are relevant to the process currently underway at the CCRC. Post Office cannot, therefore, currently simply settle with the entire claimant group, as that would throw serious doubt on safety of those 30 convictions. First of all, you obviously came into the Bates litigation relatively fresh. Can you remember how you came to find out that some of the claimants had been convicted?
I will have picked up this information, and this is probably the totality of my knowledge on this, by osmosis, by being in the office around people who were dealing with this case. And I don't have deep knowledge on that, but it seemed a relevant point to put in this email, because it seems an impediment to settlement based on what I was picking up that other people might be dealing with.
Do you have recollection of others having this sort of issue, in other words, the interrelationship between the civil and the criminal proceedings being something that was at the forefront of minds?
I don't believe so. I just knew from conversations in the office that in the claimant group there were people who had been convicted, and that would be how do you pay someone who's been convicted if you want to settle? As to detail of who was dealing with that, where that was being dealt with, I'm really not sure.
Do you think that the GLO was contested in that very vigorous way that it was, partly because to settle would have been to concede that past convictions were unsafe?
I can't answer that question. I don't have enough information, but I really shouldn't think that was the case, but I don't know.
Thank you. Those are the questions I ask, sir.
Can you just show me the date when this observation is made, please?
It'll be coming back up shortly, sir.
Yeah, that's fine, yeah.
19th March.
19th. So it's still in the same period as you were dealing with the logistics for the recusal application.
Absolutely. I had a sort of short 3-week burst and then drifted out.
Yeah, I follow.
Yeah,
That's fine, thanks.
Yeah.
Thank you, sir.
Is that it, Mr. Stevens? And thank you, Ms. Page.
Yes, I'm just doing a final check, and that seems to be everything.
All right. Well, then, thank you very much, Mr. Beezer, for making 2 witness statements dealing with 2, in effect, discrete issues. And I'm grateful to you for giving oral evidence before the inquiry this morning.
Thank you.
Thank you, sir. I've
Yeah.
heard from Ms Hodge, and we think that the best approach, subject to you agreeing, is to take an early lunch now.
Yeah.
So if we could come back for Mr Lenton's evidence at 1:20
Yeah, by all means, Mr. Stevens. We'll resume at 1:20.
Thank you, sir.